Article 27.1 of the TRIPS agreement. Okay, a quick overview. I'm going to start by briefly talking about the Alice and Bilski decision and specifically their aftermath in the context of software and business method patents. Then I'll discuss Article 27.1 TRIPS on patentable subject matter and the interpretation that in the past the US has provided of this article in the context of the review of a country's IP law. Then I'll talk about the possible relevance of these interpretations in terms of Article 31 of the Vienna Convention. And finally, I will discuss the possibility that other countries will challenge Section 101 of the US patent law before the WTO. The Supreme Court's decision in Bilski and even more in Alice has substantially reduced the level of patent protection provided to software and business method in the US. In particular, in 2010, the Bilski decision has determined what I called patent eligibility chaos, characterized by great uncertainty regarding the status of business methods in patent law, as demonstrated by a number of subsequent Federal Circuit decisions on software and business method going in opposite directions. On the other hand, the more recent Alice decision has produced particularly negative results in the context of the patentability of software. In fact, since July 2014, the PTO has rejected a patent application for software inventions in cases in which Section 101 concern was not present before. A district court have invalidated during the second half of 2014 again, under Section 101, more than twice the number of patents that they had invalidated during the entire previous year. And the Federal Circuit is being strictly applied the Mayer two-step test to find several software claims ineligible. Finally, in October 2014, Lex Machina reported a 40% drop in the number of patent cases compared to the previous year. The latest data for the past 6 months, so the first 6 months of 2015, indicated that the filing of new patent cases picking up again. But at this point, it is impossible to say whether this trend is going to persist or there will be additional adjustment of the level of patent litigation reflecting the new rules of the games brought about the Alice and Bilski decision. Thus, the relevant question becomes whether this Alice and Bilski aftermath, the limited protection that is now provided in the US to software and business methods, represent a problem in terms of the obligation of WTO countries on patentable subject matter. In this paper, I argued that this might be in fact the case. Indeed, one of the most significant achievements of the TRIPS agreement is considered to be a very broad definition of patentable subject matter. If you read Article 27.1 TRIPS in its relevant parts, we see that patents should be available for any invention, whether products or process, in all fields of technology. Moreover, patents should be available without discrimination as to the place of invention, the field of technology, and whether products are imported or locally produced. Does this provision impose an obligation on WTO countries to provide patent protection on business methods and software? WTO countries are divided on this point. An important element in this discussion appeared to be at the time when the TRIPS agreement was signed. In particular, in the context of business methods, one could argue that many countries, including the US, did not recognize patents on business methods at the time TRIPS was enacted. This suggests that TRIPS did not even contemplate this kind of patent. The history on this point is quite persuasive. However, as we'll see in a moment, subsequent interpretation of Article 27.1 provided by the US seems to have the potential of producing an entirely different result, at least for our country. The same argument could also be used in the context of software. After all, many countries did not recognize patents of software in 1994. However, the US did. At the time the TRIPS agreement was signed, the US had already recognized that software could be patented. Moreover, in the past, as I previously mentioned, the US has interpreted Article 27.1 TRIPS as requiring countries to extend protection to both business methods and software. This happened in the past, in particular in the context of WTO review of legislation, either at the time when the countries became members of the WTO, or when they enacted new laws in their systems, or in the context, for instance, of the special transitional review mechanism for China, or in the context of the WTO trade policy review of other countries. Thus, for example, if we see when Egypt became a WTO member, Japan, Switzerland, and the US presented questions about Egypt's IP law, and the US in particular asked, please explain whether an invention with the category specified below may be patented under Egyptian law if it is novel, involves an inventive step, and is industrially applicable. Point C, process inventions that facilitate the conduct of business. Similarly, when Cyprus, now a member of the EU, became a member of the WTO, Canada, the European Union, and Japan and the US asked questions about Cyprus IP law, and the US asked, here, sorry about that. Section C, 52C of Patent Law of 1998 states that the method of doing business and computer programs shall not be regarded as inventions. Please explain the reasoning behind these exceptions based on the field of technology, given that the standard for patentability in law are those called for in Article 27.1 of the TRIPS agreement. In other words, that an invention be novel, involves an inventive step, and be industrially applicable. Moreover, when Jordan became a WTO member, the US asked questions, and specifically the US asked, Article 4B contained an exclusion for mathematical methods. Jordan previously explained that this applies to only purely mathematical subject matter. Furthermore, there is no exclusion for computer-related inventions. Please confirm that this exclusion for mathematical methods refer only to purely mathematical subject matter and not to business matter or computer-related inventions. Finally, I want to show there are other cases, but these appear to be more indicative. The most interesting case, China. So China became a WTO member in 2001, and the US asked, please inform us as to whether or not process inventions that facilitate the conduct of business are eligible to be patented if they are otherwise novel, if they are otherwise novel, involved in inventive step, and are industrially applicable. And in subsequent communication in the context of China's transitional review mechanism, the US also asked, has China granted any patents for business methods? If so, how many? How many enforcement actions have involved such business method patents since their issuance? The relevance of this question becomes even greater if we consider that in the context of the WTO dispute settlement system, a number of reports refer to the Vienna Convention and specifically Article 31 of the Vienna Convention for the interpretation of TRIPS. Article 31 in its relevant part provides that a treaty shall be interpreted in good faith in accordance with its ordinary meaning to be given to the terms in their context and in light of its objective purpose. Moreover, it also provides that countries should take into consideration, together with the context, any subsequent practice in the application of the treaty which established the agreement of the parties regarding its interpretation. Now, I think that a very good, a very convincing argument could be made that the review of other countries' law at the time they enter the WTO or after they already WTO countries constitute a subsequent practice in the application of the treaty and as defined by the Vienna Convention. And therefore, it becomes obvious the viewpoint on patentable subject matter that the US is now to maintain in the international level. Indeed, at this point, it would seem very difficult for the US to convincingly argue in future WTO negotiation and dispute that Article 27.1 TRIPS does not impose protection for software and business methods. So I do not have much time. This is the, so now the question, are other countries going to challenge the US? Are they going to challenge Section 101? Well, it's very difficult to answer this question. What I think is more probable in terms is what happened between the US and Brazil in 2000. So in 2000, the US filed a petition with the WTO dispute settlement body challenging the validity of Article 38 of the Brazilian industrial property law. Brazil, in response to the US accusation that the working requirement included in its compulsory licensing scheme was in violation of TRIPS, pointed out that Section 204 of the US Patent Code appeared to function as a working requirement too. So in other words, Brazil challenged the US law using exactly the same type of argument that the EU has used against Brazil. And at that point, they settled the issue informally. In other words, I think that the US, with the Alice and Bilski decision, exposed itself to significant opposing strategies by other countries, particularly in the context of patentable subject matter. And the relevance of this result can be understood if we consider that since the enactment of TRIPS, the US has made significant use of the WTO dispute settlement system. In fact, the US has filed more than 70% of the challenges on TRIPS matters. Consequently, we can say that the US ability to promote compliance by other countries through the use of the WTO dispute settlement system seems substantially reduced. Here, I just decided to add this because this document has been made available by the WTO only recently. This is Brazil asking the US about the American Invent Act. And as you see, Brazil is asking about Bilski, is asking about business methods, is asking about the machinery transformation test. So it appears that other countries have an interest in what is going to happen here in the US in terms of business methods and software. So in conclusion, it is still unclear if Article 27.1 TRIPS covers software and business methods. In the past, the US has interpreted Article 27.1 TRIPS in a way that to cover software and business methods, and therefore at this point, it would seem very difficult for the US to argue that TRIPS does not require countries to protect them. Alice and Bilski has reduced substantially the level of protection provided to software and business methods in the US. Currently, our country seems to provide less protection to these subject matters than other countries like the EU that at least formally have always proclaimed to be in favor of software and business methods. The result for the US is significant reduction in its ability to promote TRIPS compliance through the use of the WTO dispute resolution system and international negotiations. Then in the paper, I also talk about NPEs. As we all know, business method patents and software patents are very important for NPEs activity. So in the paper, I ask whether, considering this international perspective, there will be an additional intervention of the Supreme Court on patentable subject matter, and therefore whether, in fact, Alice and Bilski are the end of NPEs, as someone has argued. And then I also talk about patent reform. Thank you.
So I have a comment to the question. My comment is that we're noticing the U.S. Trade Representative is pushing for a very expansive view of what is patentable subject matter, where we have the legislature and the courts possibly reining that in. And so I think this is a conflict, I think, which would be just very, very big topic here for your paper. My question has to do with your interpretive methodology when you're interpreting the treaty language.
Okay.
Are you looking at what the text, the words mean, the intent of the drafters at the time? I mean, you talked a little bit about that, but I think it's a little bit like constitutional interpretation. right? So, I mean, so what do you think we should be relying on? Should we care what the framers thought, the Constitution or the national governmental legislators thought at the time that they drafted TRIPS, or should it be in a sense a living, breathing treaty, right? Looking at what do these words mean today? And I think this is important for, this area of law in addition to, common law.
Yes. Well, my position would be probably to interpret the TRIPS agreement in terms of what the terms mean today. Also because subsequent activity, like in the case of the US, have produced certain interpretation of those words, but also from other countries that had an impact on legislation of other WTO members.
Right.
So,
well, wouldn't the subsequent practice not have to be all of the members as opposed to a subset for it to actually have an interpretive effect? Or I mean, how many members would have to engage in the subsequent practice for this to be relevant? I guess.
well, in terms of, if we consider the review of other countries' law, if you're talking about the specific subject of business methods, or you're talking about the overall review of other countries' law, because in that respect, pretty much all the WTO countries have participated in that activity. So we have here examples of questions that are presented by the US, but there were also other countries that presented questions on other aspects of the law. What I found to be interesting, and that could raise the issue whether there is an agreement in terms of what the specific words of Article 27 mean, is that when other countries talked about or asked about Article 27.1 and the exemptions of other countries, they did not talk specifically about business methods. They just said, so could you explain as which are your exemptions, the exemption is in your law, and how they are compatible with what we say in Article 27.1. The US was the only one to say, you have one of your exemptions or your exceptions is business methods or software, and we don't think, like in a way, they say we don't think that's compatible with Article 27.1. So there can be discussion there. We will need more decision from WTO panels or WTO appellate body to know exactly how that would be resolved. But what I'm discussing in the paper is more that this gives rise to opposing strategies from other countries, so undermines the ability of the US to use the system in a way the US used the WTO dispute settlement system before. That's what I'm saying. It creates that kind of uncertainty. The US appears to have argued certain things. Other countries might use that to say, well, let's say that India wants to add some kind of provision in their patent law saying that certain pharmaceuticals are not patentable. At that point, the US might want to, might be in a position where they're interested in challenging that provision, and you could see maybe India saying, okay, like Brazil did in the past, what about business methods then? So that's what I'm saying in the paper. I'm not going to say this is the interpretation because the US said that. Makes sense?
So 4 areas you should look at. The first one is the distinction between discrimination and differentiation. And the reference point will be China, the Canadian pharmaceutical case. The second one is with respect to compulsory licensing, they make a special exception with respect to software. So if you look at Article 31, they have a special exception. So you can actually make an argument saying that even within the TRIPS agreement, they differentiate between software and non-software products. And that's within Article 31. And the third one is about subsequent practice. You might want to look at the China enforcement case, because they basically rejected all the FTAs and say this will not constitute subsequent practice or subsequent agreement within the WTO interpretation. And what you're doing is basically focusing on one country's interpretation.
Yeah, but in fact, I said it's not what I'm proposing, and what I'm not saying in the paper, because the United States has this question, these represent the correct interpretation of Article 27 TRIPS. I'm not saying that in any way. I'm just saying that.
But so that goes to my fourth one, is that there's a distinction between the estoppel argument and Vienna Convention interpretation argument. I think you're going more to estoppel as opposed to a Vienna Convention interpretation.
Okay.
Yeah.
I'm done.
Still 2 minutes.
Yeah, there's a minute 50.
Just a quick question. I wonder whether you encountered any follow-up on the U.S. questions being posed, any
Yes.
internal documents from the U.S., for instance, discussing whether an action should be taken against the country.
No, I didn't find that. I found the answer provided by the countries on those questions. Some countries, like such as China, explained that the way in which their provisions on patentable subject matter was worded did not exclude the patentability of business method or software. That's what they said in their answer. So they said under our law, it's possible if they are otherwise novel or have industrial applications and so on and so forth. Other countries, like such as Cyprus, expressly said there is still uncertainty regarding the patentability of business methods, so we don't think that our provisions on patentable subject matter is in any way, excluding patentability of business methods is in any way in conflict with Article 27. So it is going in both directions. Yes.
So one way to frame this issue, right, what's the best ultimate result, right? Do we want a broader interpretation or more narrow interpretation? And the challenge, if your argument is estoppel, right, so you're saying, okay, here are developing countries, here's what you can argue against the U.S., but perhaps maybe the argument should be, hey, U.S. Trade Representative, you really need to be thinking about this expansionist position you're taking, because ultimately it reduces the flexibility we have at home.
Yes.
And this is important not just in tax, but in other areas as well.
Yes.
So I think when you're making your proposals as to where do we go from here, perhaps rather than say, oh, sorry, world, we have to have an expansionist policy because of the fact that people are being inconsistent here, maybe instead we want to go back and say, look, U.S. Trade Representative or other trade representatives that might be taking these kinds of expansionist positions, perhaps you need to tone it down a little bit.
Yes, makes sense.
Yeah, no, I think it's a great question.
Thank you.